Innocent until proven guilty is a term often heard in the criminal justice system. But where does it come from, and how effective is it in maintaining justice today? This video serves to explore these questions and more.
The concept of innocent until proven guilty has been submerged in jurisdiction since the beginning of time and has commonalities amongst almost all legal systems. It can even be seen in some instances of the Bible, such as when Moses commanded that for truth to be found, testimony of 2 or more witnesses was required. One could conclude the reasoning behind this would be on the basis that if 2 parties had conflicting stories, nothing could be proven and the person would have to be presumed innocent. The original principle of the Maxim is to ensure that every person, regardless of their background, would be presumed innocent until proven guilty. In addition, they would be protected from being forced to give testimony that could be incriminating to themselves and assured that everyone was being looked at under the same lens in an open court with equal access to legal representation. Today, the maxim, innocent until proven guilty, is primarily used as a mechanism for the courts when evidence is being set forth. Some questions to ask ourselves. Did the maxim lose its core values when it was transitioned to American common law? What are the gaps from the original maxim and how it is used today? And can we go as far to say that the concept of innocent until proven guilty no longer exists?
The maxim of innocent until proven guilty developed as a group of absolute rights that every defendant was due. However, when this ideal was introduced to the development of the American system, there was a large shift in how this ideal was being applied in practice. Instead of the broader original meaning, which led to a set of inherent rights across the justice system and procedures, a new understanding developed which effectively contained the idea of innocent until proven guilty to evidence and procedural rules within the courtroom. In the Canadian context, we believe a similar view can be taken. Whereas this maxim was once used to defend minority groups, create social change against unjust treatment such as torture, and protect defendants from being coerced into giving self-incriminating testimony, in Canada, the main use of the presumption of innocence can be observed to be contained to procedural rights within the court rather than the broader original scope.
We've now heard about where the maxim originated from, but how does it present itself in the Canadian legal system today? Today we can find it in Section 11D of the Charter of Rights and Freedoms, which states that any person charged with an offense has the right to be presumed innocent until proven guilty according to law in a fair and public hearing by an independent and impartial trial. The purpose of the law is to maintain the innocence of the accused until they are proven guilty, and to ensure that only the guilty are those ultimately charged by the justice system. But as we will see, there are some instances where the matrix is in tension with what happens in practice, such as the case in pretrial detention. As it sounds, pretrial detention is when someone accused of a crime is held in prison until the time of their trial. This typically occurs in cases where the nature of the crime is serious or if the accused has a criminal record.
However, in Canada, over the past 30 years, the rate of pretrial imprisonment has tripled. As this trend only continues to increase, a moral contradiction in our criminal justice system becomes clear. We are detaining people before trial in a system that preaches their innocence. Some do argue that the presumption only has application within the confines of the criminal trial. There is codependency with the burden of proof. Others argue that depriving someone of their freedom on the basis of expected criminal behavior before their guilt has ever been established consists of a clear violation of 11D and shifts the purpose of our criminal justice system towards one that is preventive. On the one hand, this criminalization of conduct at an early stage promotes efficiency and public security, although, on the other hand, it erodes or waters down the presumption of innocence, which can further lead to a re-questioning of the morality of criminal justice in Canada. Also, treating technically innocent people as guilty is more than just morally wrong, as it also has negative psychosocial impacts on the individual. In bail hearings, judges may be weighing evidence inconsistently and may further be axing themselves on guilt determination to decide on whether pretrial detention is needed. In a system that structurally oppresses minority groups, issues and stereotypes may arise in the process of determining whether an individual is a danger to society.
Before a constitutional referendum in 1997 concerning pretrial detention, the Irish Supreme Court had maintained that the presumption of innocence almost completely restricts any provision for pretrial preventative detention, although many critique this view for being too absolutist.
We can ask ourselves the following questions. Should recidivism alter the presumption of innocence's protections from pretrial detention? Should we only apply the presumption of innocence inside the courtroom? And is the presumption of innocence even compatible with pretrial detention at all?
Created using Powtoon.